Oh, I'm live. Oh, hey. Whoops. Um, all right. Okay, so this live stuff's kind of not that easy for me to do because I'm not that smart. Anyways, I did a little one yesterday. I didn't really make it public. I think I posted it up there, but I'm going to start talking to people a little bit about some of these things. We have to start understanding if we're going to start interacting with our government officials properly. We have to understand what the rules of the games are. You know, it's a fairly complex subject. It's not something that can be explained in a 5-minute video. Requires a little bit of research, some more reading, because most research has already been done. I'm going to be laying it out for people. But it's more getting a better understanding, kind of wrap your head around how your governmental structure, how they're put in place here in the United States of America, your independent nation state of wherever you're at, Utah, California. Okay. So there's a lot of issues that concern jurisdiction, status. Jurisdiction, of course, is what gives people the power, the authority to do things to you or for you. So very important for us to start to understand what that is. So we start looking at, from the federal standpoint, legislative jurisdiction and how that works. Oops, sorry. Um, so your Congress, your federal senators and representatives that collectively make the Congress of the United States assembled, or Congress of the United States of America assembled. When they're enacting legislation, they write for several different jurisdictional authorities. So when they're writing legislation which affects the several states of the Union, and the population at large, the general populace across the continental and including Alaska and Hawaii now. Um, Congress is limited by its authority, which is delegated to it in Article 1, Section 8, 17, Constitution of the United States of America, which says to exercise exclusive legislation in all cases whatsoever over such district, not exceeding 10 miles square, as may, by cession of particular states and by the acceptance of Congress, become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. Now, there's two other jurisdictions that where Congress is a lot less restricted, and that would be federal territories under Congress's legislative jurisdiction, outside the several states, and on the federal enclaves, which have been ceded over to the United States for constitutional purposes. We just read. Erection of forts, magazines, arsenals, dockyards, and other needful buildings. That's the constitutional purpose. Then they get property, land, ceded to them out here in the several states. And then as pertains to operation of the United States government itself, its internal organization, its internal rules and regulations for the people that work for government. Those would be what would be determined to be called sovereigns, which are the people, the real living people sitting in the offices of sovereignty, which is the actual structure of your government. Now, recall Article 1, Section 8, Clause 10, Book Law of Nations, Book 1, Section 1 talks specifically about what sovereignty is, what sovereigns are, and what sovereign authority is. So we're going to go back into that again. But it's that offices of sovereignty and how those are delegated, how those are operating, and people, the rules, regulations apply to those persons, those special class of persons. You got to remember that. Now, the authority that Congress exerts as a government for its own federal territories and the operation of the United States governments, that authority does not extend to the several states, which would be the independent nation states, and the population, the general population at large. Members of societies that are out here in these geographical areas called states. So um, now the territorial authority of Congress is constitutionally delegated to them also at Article 4, Section 3, Clause 2, which says Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. So, and in order to maintain a division between those two legislative authorities, constitutionally granted legislative authority, one over the, actually three, one is for the general population, the other is for their territorial areas over the 10-mile square District of Columbia and their people. Um, But there's been put into place some rules and regulations, and one of those happens to be a requirement that any act of Congress that has general application and to the several states, the general population at large, must be published, and the implementing regulations must be published in what's called the Federal Register before any given statute which has been promulgated or written by an act of Congress has any general application. Now, your United States Supreme Court has ruled on this a number of times about the mandate for regulations to be published in the Federal Register before any United States statute is applicable to the several states, independent nation states, which are federated, or your general population at large. One is the California Bankers Association v. Schultz, which is a tax case. But it says, because it has a bearing on our treatment of some of the issues raised by the parties, we think it important to note that the Act's civil and criminal penalties attach only upon violation of regulations promulgated by the Secretary. That would be Secretary of the Treasury, or Department of Treasury. But if the Secretary were to do nothing, the Act itself would impose no penalties on anyone. There's another case, the Hotch case, the Administrative Procedure Act at 551 of Title 5 of 44 U.S.C. require publication irrespective of actual notice as a prerequisite to issuance of a regulation making certain acts criminal. So there's the Administrative Procedures Act, which is 5 U.S.C. 552, and the Federal Register Act, which is 44 U.S.C. at 1501. Now, USC is United States Code. I talked about that briefly the other day, but what that does, it kind of consolidates all the various statutes into a codified sort of an index so that it's easier to kind of go through because the statutes at large are the actual law. United States Code kind of codifies things, simplifies things, pulls together all that massive legislation, how things tie together, because a lot of legislative acts impact a lot of other legislative acts. So, but the United States Code is sort of the index guidelines that we rely upon, but it requires, and that's what those are: 5 U.S.C., 44 U.S.C., Title 18, Title 26. We're going to be talking about. So, but those, the Administrative Procedures Acts and the Federal Register Act require publication of regulations, delegations of authority, uh, implementing rules and regulations. That they have to be published in the Federal Register if they have any general application to the several states, the independent nation states, or the population, you and I. They're not registered in the published in the Federal Register, sorry. They then have limited application, which is also detailed for us if we're reading at the United States Code 44, section 1505A. Talks about the documents to be published in the Federal Register. There's proclamations and executive orders, documents having general applicability and legal effect, documents required to be published by Congress. So we're talking about presidential proclamations, documents or classes of the documents that the president may determine from time to time have general applicability and legal effect. Other documents that may be required to do so be published by an act of Congress. So basically, every document order which prescribes a penalty or has general applicability and effect, legal effect, must be published in the Federal Register. So this leads us then to start understanding. We need to begin to understand what's really an act of Congress that applies to us. What's a criminal statute that might apply to us? What's a state? What's a territory? What's the geographical area of the United States? So that's the next little section that we're going to be going into, and I'm going to come back and do one a little bit later about that because I've talked about it a little bit. But it becomes very important when we start to read that we understand the definitions of the words that are being used in that particular circumstance. And I'll show different examples where a definition of a state in one particular legislative act has a different meaning and a definition than what it means in a separate legislative act of Congress. Okay, they've got all these word games they play and try to keep people confused. Make it very difficult sometimes to understand what state are they talking about, what jurisdictional authority is being brought to bear in that particular circumstance, in that particular matter. But with a little bit of study and a little bit of research and trying to understand how things are, and it's laid out pretty clear now that the most research has been done of what's being applied and what's applicable to you out here in the States. And we're going to be, like I said, we're focusing primarily on Title 18 issues, criminal issues that are being brought to bear against us for use of cannabis, and how it is that we can figure out if that really applies to us or not, because Title 18 happens to be one of those that there are no implementing regulations been published in the Code of the Federal Register. Also in the Code of Federal Regulations, the CFR. Okay, so by the terms of the Federal Register Act, then there can only be 3 applications of penalty statutes classified in Title 18, it's Criminal Code. That has to apply to agencies and officers, employees and agents of the United States, which goes back to Congress's ability to regulate its own internal affairs and operation of the United States government. Territories and incidental possessions of the United States under Article 4, Section 3, Clause 2. Oh, and then also United States Admiralty and Maritime Jurisdiction, which we don't really talk about too much, but that's one of the, those are the two of the 4 actual types of law that have constitutional authority, been constitutionally allowed, which is your at law, which is common law, your equity, or chancery is what it used to be called. Then you've got admiralty and maritime, which we deal primarily with contracts, international contracts, and then and so those are the 4 areas that that's all they can bring to bear. But most of your courts, in fact, all of your courts now operate in civil law, Roman civil law, which is a non-constitutional form of law. And we'll talk about that later, how I believe that they've been able to do that, and it's also constitutionally mandated. They've kind of gone through the back door, but I want to get lost on those things. But so that's what we're going to be talking about next is definition of words and whether or not you become, are you an agent, an agency or officer, employee, agent of the United States, or are you in a territory and insular possession of the United States, or are you under admiralty and maritime jurisdiction of the United States? So that's what we'll start to look at too, about how those, what the definitions are those, and how it is that you can become one of those even without knowing it, which is what they've tried to do to everybody, and how it is that we can defend ourselves against that. But first of all, we have to go back and get a better understanding of these words, definitions, how to read legislative acts. So that's the next section I'll be working on. So love everybody. Have a good day. Try to come back later. I'm not feeling too good, but once again, here's my closing pledge. Pledging to this project, to you, your family, my neighbors, the other species on this planet, my life, my fortune, what little bit I have left, my sacred honor, to get things straightened out so that we can regain control of our governance and we can have a real life, we can have a proper, meaningful experience here, and we can throw off this chains of tyranny which have been being placed upon us. Get back control of our governance and put these people that are in power right now that have violated, egregiously violated, most of the terms of that contract known as the Constitution. Get back, get things back going in a better direction so that we have some possibility of surviving, the other species on this planet, of surviving long term. So, all right, love everybody. Have a good day. I'll talk to you later.